And the next section is a very important section because it covers the core of what we're doing in this course. In business law, generally, everything relates to one company or one individual making agreements with another company or another individual. And these agreements bind people to do things. So what we've seen over the course of time is that we have to create, the system has to create obligations, okay? If I say to you that I will shovel your snow, and you say to me, well, I will pay you $20 every time you pay the snow, you plow the snow, then, that binds both of us, you and me, to a promise. We've promised to help one another. We're both mutually benefiting from that contract. It's I'm going to get $20, you're going to get your snow plowed. So both of us benefit. So the problem or the challenge is that these contracts are private. In a general rule, it's just between you and me, and nobody else is involved. So it's really nobody else's business. So the court system has always looked at this and said, well, this is interesting. This is a situation in which the government's not involved, the public is not involved, no one else is being hurt by it. How do we handle it? So contract law has evolved out of this odd situation. What society has said, in order to facilitate business and business obligations and ensuring things are done within the letter of the law, within a just and civil society, we need to create a section of law that looks at or overarches and enforces these promises that people make to one another in the form of a contract. So over the course of many years of history and many years of experience and precedent, the contract law or the provisions of contract law have been developed. So what we're looking at is how are those provisions applied by the courts, and what are the obligations if I make a promise and you make a promise? What are the obligations? And then what are the ramifications if I don't fulfill my promise or you don't fulfill your promise? What can the court do there in order to A, make things right, or B, impose some sort of penalty? So that's exactly what this section is about. And this goes on for a lot of material. There's a whole bunch of things, because on the surface it sounds pretty straightforward. What we're trying to do is to enforce promises between individuals or companies. But there's all kinds of permutations, like, well, how do I know that an actual promise has been made? And well, one of the things the courts have done is they've come up with this concept of essential elements. Okay, we're going to look at what are some of the essential elements of a contract in order to ensure that it is indeed a contract. And when we talk about this essential elements, we're talking about really three elemental parts. Every contract has to have something called an offer, which is what someone provides. I will plow your snow. That's an offer. The acceptance is you say, yeah, I will let you plow my snow, or I want you to plow my snow. But there's also a fundamental part in order to make that a contract, and that is consideration. Consideration is that mysterious third element that basically says that both parties have the benefit from the contract. And there has to be something to provide that benefit. So if I said to you, I will plow your snow, and you say yes, you're getting a benefit of that. You're getting your snow plowed, and you agree to have that done. But what am I getting out of it? Well, to look for consideration, what we need is some part of that offer that talks about consideration. for $20 is the consideration part. I am getting $20 out of it when I plow your driveway. So that way you're benefiting, there's a benefit to you, and there's a benefit to me. So whenever a contract exists, you got to have those three essential elements. You got to have an offer, you got to have an acceptance, and you had to have consideration. So those are the building blocks of a contract. Now we're going to look at that. Part and parcel with those three essential elements, there's a whole bunch of other things that allow a contract to go forward or stop a contract. Legality is one of the things. The courts are not in the business of enforcing illegal activities, okay? So if I make an agreement with you to do something illegal, and you say, yeah, that's great, I'll pay you $200 for doing something illegal, you're going to say, well, okay, that you do have the essential elements of contract there. You have an offer, you have an acceptance, and you have consideration. But unfortunately, the court will look at it and say, that is an illegal activity. I'm sorry, we do not support legal activities, and we will not enforce that contract. So legality has to come into a contract. It has to be legal. There are a whole bunch of other factors too. How old you are, whether it needs to be in writing or not, these sorts of things. And we're going to look at a bunch of those as we move through here. Sometimes contracts can be verbal. Like, for example, what I just said to you would be an example of a verbal contract. We don't have anything written down. Now, fundamentally, the courts say that's fine. You can do a verbal contract. There's no problem with a verbal contract for 99% of the contracts that are written. Okay, but there are other types of contracts, that 1%, that the courts have said we can't go on that, like the sale of land. The land is registered, there's deeds involved. We can't go on a verbal agreement there. It has to be written down. So there is a statute called the Statute of Frauds, which is really designed to say these types of contracts must be written. So we're going to look at the Statute of Frauds as well. We're going to also look at contracts that, on the surface, it looks like contracts are very simple, but sometimes there's a situation where a contract is implied. So, as I say to you, when we have an offer and acceptance, as I just laid out, that's very much what we call an express contract. All the elements are clear, visible, you can see them, they're there. That's an express contract. Those are the ones that we like because we can clearly identify the components to it. There are other contracts that are not so expressive, and these are called implied contracts. When you walk into a store, for example, and you go to buy something, and you go up to the cash register, and you pay for it. There was really no offer acceptance there, was it? But is it a contract? Certainly is. So this is what we mean by an implied contract, and we're going to look at some of these implied contracts because they do happen. We also have other contracts that have these conditional things written in them. I agree to do this if you do something. So there's conditional agreements. There's limitations on contracts. You have to do it by these sorts of things, or exemption clauses that says you won't do something by. We're going to look at different forms of contract. There's all kinds of different contract forms. We got this parole evidence rule, which is a little point of law that defines whether or not a contract is really in place. There's an interesting term called privity of contract that we're going to look at. And a privity of contract is, as I described up in the front, if we have a situation where someone makes an agreement with someone else to do something, nobody else is involved. And that's effectively what we mean by the privity or the privacy of a contract. It's just between a couple of individuals or a couple of companies. The world is not involved. It has no implications on the rest of the world. And so we look at this concept of privity of contract in relation to how are others affected by this, or how do others influence the contract. We're going to look at termination of the contract. what constitutes reasonable termination of contract? The one that's most obvious that jumps out at you is performance. If I have a contract with you to plow your driveway for $20 and it's a valid contract, I come and plow your driveway, you pay me $20, contract's done. You know, we did it. You paid the $20, I plowed your driveway, as was the agreement, no problem. But again, you know, the problems arise when things don't get done or don't get done to people's satisfaction or these sorts of things. So we'll be looking at this idea of what constitutes termination. And then we look at some of the remedies if the contract doesn't go through, and we call this breach of contract, when I don't do what I said I was going to do and you don't do what you said you were going to do in terms of the contract. Government has stepped into contracts, and this has always been challenging turf for legislatures, because effectively a contract is a private affair between two individuals. So government said, well, that's none of our business, we shouldn't really step into it. But there have been examples and cases where people have been shirked out of a lot of money, didn't know what they were doing, incapable of determining, all kinds of reasons why society as a general rule has been hurt by people being taken advantage of in contract. So what government has done in several cases is they have laid out certain rules that contracts must operate under. The Sale of Goods Act in Newfoundland and Labrador, which we'll look at, the Sale of Goods Act is an example of that. It lays out, or it writes legislation that says, if you're going to sell something, here's what you need to do in order to make the contract valid. So the Sale of Goods Act is something we're looking at. And the Sale of Goods Act is right across Canada in the various jurisdictions. We talked about it, it's a jurisdictional issue. Well, normally if the sales of provincial goods, the provincial government would make the Sale of Goods Act. We're going to look at common mistakes in contract. I didn't cross a T or dot an I, or my spell checker didn't work right, or I didn't put a decimal place in the right place. Those things can affect the contract and make it spoiled, can spoil it. We also got something called misrepresentation. And misrepresentation is really, most times when we think about misrepresentation, it's someone at something that they shouldn't be at. So for example, I say that I stand in for Walmart company because I'm online, okay? We're online. You buy something from what you think is Walmart company, but you're actually buying it from me, and I just use their name to sell stuff. I'm not Walmart. I've misrepresented myself. You think you have an agreement with Walmart, you actually have an agreement with me, and misrepresentation happens a fair bit, particularly in illegal activities, and these cause problems for contracts. We're going to introduce the word duress. Duress means I twist your arm. If I could twist your arm, let's say, for example, let's go back to that snow clearing contract where I say to you, I'll shovel your driveway if you pay me $20. But at the same time, I have you in an arm lock and I'm twisting your arm and I say, if you pay me $20. So what happens there is you're not free to enter the contract. You feel that you're under some pressure to enter the contract. And if, for example, you thought about it after the fact and said, no, I was under pressure to enter that contract, I don't feel comfortable with it, you're going to argue that you are under duress and that the contract is no longer valid. And sometimes, too, we run into problems with this final point, and that is assignment of a contract. I agree to shovel your snow, you agree to pay me $20, but I have a cold, so I get my buddy to do it for me. So he goes off and shovels your snow, and you pay him $20. I've effectively assigned the contract to someone else. And what are the implications of that with regards to the validity of the contract? Okay, so those are most of the things that we're going to be looking at, or components of those things. So that's the key thing that you want to be able to take away from this contract section. If you want to know what sections that we're looking at here, or where to find the sections in your textbook, is chapter 7 and 8. And if you look at every other textbook, it tends to be falling somewhere in around chapter 7 in textbooks of the same concern. So in this particular textbook that is for this course is chapter 7 and 8. And of course, I've got information in Unit 3 here, and that is relatively updated, but I will add some stuff to it, or I just wanted to reserve the right to add some stuff to it as we move along. But I've got most of the material in there, and the slides that you're looking at here are found there as well as in the news section of the course. Okay, so the very first thing that we need to kind of look at is what exactly is the definition of contract law. So contract law is really a whole body of law. It is you'll see lawyers, for example, lawyer's office, any lawyers that you look at will have their specialties, okay? And they will indicate what they do in what kinds of modes of practice they look at. Most of them will have contract law there because contracts is a pretty common one in business all over. So it's a body of law that largely developed in the courts. What we mean by there is that if we talk about stare decisis, which is the precedent, okay, the English word for stare decisis are really precedent. Contract law was invented, and the law surrounding it is really a baby of the court system. It's not government that made the law. It's not legislative. It doesn't come out of the legislatures. It's not statute oriented. It is developed over years and years and years of dealing with contracts in the court system, and the precedent that has arisen from that has helped develop the body of law that we're talking about here today, which is kind of unusual because most other laws come out of government bodies in the form of statutes. So contract law governs both oral and written agreements associated with the exchange of goods and services, money, and properties. So, you know, a couple things that we need to take away from that is that contract law covers goods, physical, tangible goods, but it also covers services, which is a very big part of our economy. If you think about services representing 60 to 75% of the economy, contract law covers that too. And again, me shoveling your snow is an example of a service as opposed to a good. But contracts also cover money and properties. And the thing is with properties is we have the Statute of Frauds says that all those types of contracts must be in writing. So government has stepped in to, as I mentioned, the government has stepped into contract law for common Joe purchases with a piece of legislation called the Sale of Goods Act. The Sale of Goods Act really looks at most of the products that you and I will buy in our lives are covered under the Sale of Goods Act. So a lot of the small contracts that we do every day, going to Walmart and buying a toothbrush, are covered under that act, okay? So a contract really has to have certain key elements, as I mentioned. And the very first thing is the fact that it is voluntary. I mentioned the word duress a few minutes ago. A contract has to be voluntary. You and I have to voluntarily enter into an arrangement to agree to provide a service or provide a good in a certain amount of time for a certain degree of consideration. So they could be considered as promises, right? So it's a voluntary exchange of promises, and it could be written, could be spoken between two or more parties that creates obligations that are legally enforceable by the court. So that's fundamentally the definition of a contract. It has to be voluntary. It doesn't need to be in writing for most contracts. There's two parties involved at least. There can be more. And the fact is that out of that contract, there are obligations arising for both parties, and those parties are then answerable to the court system if they don't do what they said they were going to do. The law will consider a contract to be valid if the agreement contains all of the following elements. So, as I mentioned, we got the three kingpins. Okay, you have to have an offer, you have to have an acceptance of the offer, and you have to have consideration, which is an intention to actually do something, and both parties will benefit from that doing. So the offer, acceptance, and intention between the parties create binding relations, consideration to be paid for the promises made, a legal capacity of the parties to act, genuine consent of the parties, and legality. Just to kind of put some finer points on those, the offer and acceptance is pretty straightforward, but there are bubbles in that or wrinkles in that too that make a difference. Let's say, for example, I said to you, you had a car and you were going to sell it. And I said, well, I'll offer you $5,000 for it. And you say, no, I need 10. Okay, I say, I'll offer you $8,000 for it. And you say, no, I need 10. There's no contract formed there. But the fact that we were going back and forth, who's making an offer and who's making the acceptance, that kind of gets gray when we go back and forth, because you said to me in the first instance, I want 10. So are you offering it to me for 10? Are you making the offer when you say that? So that's where we get into some of the intricacies of offer and acceptance that courts will often look at. Who made the offer? Who did the acceptance? The intentions to create binding relations. If I said to you, I'll sell you my car for $5,000 and my car is worth $30,000, you know that, I know that, but could you hold me to that? Could you say, well, you said you'd sell it to me for $5,000, and if you don't do that, I'm going to bring you to court. Well, we don't really have a contract, and the courts would throw it out, because I would argue that I said it in jest. I did not mean that I was really going to sell you my car for $5,000. I was just being flippant. Okay? So the intention between the parties to create binding relations has to be there. If I say something, it doesn't bind me to the contract. If I said to you, I'll sell you my car for $5,000, knowing full well that I really won't sell it for $5,000, then I had no intention to create a binding relation. And if there's no binding relation, there's no contract. Consideration to pay for the promise. Now, when we think about pay, you say, well, I could really trade you something. There's no need for me to give money necessarily. Do contracts apply when no money is involved? Yeah, they do. It doesn't matter what the payment is. The payment could be a service, it could be an exchange, could be something besides money. But the fact of the matter is there has to be something in exchange that is of fair value to that. Legal capacity. When we think of legal capacity, there's a number of factors that come into play that affect legal capacity. The very first and foremost is my age. I have to be of legal age, which in Newfoundland is 18. I have to be of legal age in order to create a contract with you. If I'm too young, no matter what I do, I can't make a contract, a legally enforceable contract. We can do it, but it's not necessarily legally enforceable. So capacity, probably the one that stands out most is age. And kids who try to buy and sell things or have a contract for a job, really, those contracts are not enforceable to any great extent because of the fact that their age is not there. But maybe let's go on the other end of the spectrum. You go and buy something from me and I'm 80 and I have serious Alzheimer's. I don't know if it's day or night. And you say to me, will you sell me my car for $5,000? Your car for $5,000? It's your sure thing. Well, okay. You're going to say, well, we got an offer, we got an acceptance, consideration, $5,000 the car. But the fact of the matter was, I was not of sound mind. And because of that, I had no capacity to contract. And the court would throw it, the court would throw it out because I had to have capacity. So age, my they use the word insanity, but the fact of the matter is I have to have my faculties about me in order to know that. That includes if I'm drunk. That includes if I'm intoxicated in some way. That includes if I'm incapacitated in some way. It doesn't matter. If I lose that capacity through one way or another, no contract. Genuine consent of the parties. And we need to say, well, what does genuine consent mean? And this is a gray area, is really, the court has to be proven that both parties wanted to really enter this agreement in full knowledge of what was going on. And if you can convince the court that there was no genuine consent, the contract would be null and void. And we already talked about legality in the sense that I can't make a deal for something illegal. So either one of those elements lacking will wash away the contract. There will be no contract. So I've just put those things here in this graphic. Okay. So we need to think about these contracts. To create a valid enforceable contract, the parties to the contract must first agree that there is an agreement. The offer and the acceptance is known as consensus. So we have to have this mutual feeling that you and I are making a deal. This mutual feeling that, yeah, we do have some agreement in place here and that we want to enter into it. The consensus means that the valid offer is made and that the offer is acceptable for a specific price, called the consideration. That is the real test. Did I benefit and did you benefit? If we both benefited, there is consideration there. So if I promise to shovel your driveway for nothing and nothing in return, it is not a contract because there is nothing coming back to me and the court will not uphold that. It's what's called a gratuitous promise. The very fact that I make a promise that does nothing for me, and as a result, there's no contract. So consideration is a promise of something of value given by the promisor in exchange for something of value given by the promisee. So each party to the contract must also have the capacity to enter into an agreement. So minors, intoxicated persons, and those under mental affliction may have insufficient capacity to enter a contract. Some types of contracts may require formalities such as memorializing in writing, and that is true for certain contracts. The Statute of Frauds said, for example, the sale of property, land needs to be in writing. So these are the key elements for a contract to happen, and we need to be aware of these. So we'll look at this concept of a contract offer. So a contract offer. The offer really is a tentative promise. It's a tentative promise because I need to get your acceptance on it before we go any further. So I will sell you my car. That is the tentative promise. The offer must contain specific terms, so for $1,000. The offer must contain important terms of the contract, such as who the parties are, you and me, subject matter of the car, and the price. So pre-contract offers such as an ad for my car for sale. So I put it up on Newfoundland Classifieds, for sale, one car, $1,000. That's not a contract because there's no acceptance, there's no consideration in that. So you can't force me to sell. You know, this is the typical situation where, let's say I put an ad up on Newfoundland Classifieds, and I meant to say $10,000, but I inadvertently wrote $1,000 on the ad, okay? So the ad was there for $1,000. In my mind, it's $10,000. You come to me and say, I'll buy your car. And you say, well, $10,000. Oh, no, you said $1,000 on the ad. It's not enforceable, and you're not going to benefit from that because there's no contract in place when I put an ad up. So this is an important one. We hear this a lot, you know. In a store, for example, they've mispriced an item. So an item that should have cost $100 is for sale for $10. Or an item that, you know, has a wrong sticker on it or something like that. We bring it to the cash and we've been told that the store has to sell it to you for that price. No, the store might have a policy that they'll sell it, but the law does not say that. The law says that that is really a pre-contract offer. A price tag is nothing more than a pre-contract offer. It is not a contract. They use a neat word, and I like the word, invitation to treat. You know, it is an invitation to treat. When you walk into Walmart, Walmart is a private entity. You come into their store at their leisure, okay? The doors are open. You say, well, anyone can walk into Walmart, sure. They can reject you. They can say, no, Paul, you're not allowed in here. They can do that. There's nothing to stop the company from doing that. So they operate a store which works on the basis. The whole premise of that store is that people come in, they look around, they pick things up, they bring them to the cash register, they pay for them, and they leave. Okay, that's the model that is being used. That model does not say that everything in the store is for sale or that they have to sell everything that's in the store. There's nothing to prevent them from saying, no, we will not complete the contract with you. So this is what is known in the industry, in the legal industry, as invitations to treat. So if I put a sign on my house or a sign on my car and you misread it or I have it put there wrong, I do not have to do anything to make that, fulfill that contract at that price. So when a company or business encourages the purchase of a product or service through advertising, this is what's called an invitation to treat. So advertising per se is not a contract. It's an invitation to treat. So a contract occurs when the product or service has actually been purchased. So it's that point of purchase where the contract happens, not the advertisement. Now, you could argue that offers are made, but offers don't last forever. So there's a period of time from the point the offer is made. I will shovel your driveway for $20. You can say, let me think about it. Okay, let me think about it. So I have made the offer, you have not made the acceptance. What's going on in that period between the offer and acceptance? Well, until the offer is accepted, no legal rights arise. The offers are not always accepted. Even in cases where the offeree may wish to accept, events such as death or illness may occur that prevent the formation of an agreement. So God forbid that, I say to you, $20, shovel your driveway, and you go out and you have an accident, you're in no capacity to fulfill that. So there is no agreement. If you're sitting in the hospital bed thinking I'm shoveling your driveway, I'm not, and I don't need to because there hasn't been no agreement. An offer will also lapse when a direct or indirect response does accept the offer unconditionally and in accordance with its terms. An offer also lapses if the offeree rejects the offer outright. The situation is when I turn down the offer, or let's assume you turn down the offer. You're the one, I'm making the offer to shovel your driveway. And I get a direct or indirect response, does accept the offer unconditionally and in accordance with its terms. You say, yup. Okay, that's basically what you say, yup. We still may not have an agreement because there's still no consideration going on there. That point of exchange has not happened yet. We can also think of you rejecting the offer. No, I'll pay you $5 to clean my driveway, but I won't pay you $20. That makes the contract invalid. There is no contract. Offers may also lapse when the passage of time or when the occurrence of a specified event. If no time is specified, the court will consider what's reasonable. Okay, what does that mean? And this is where we run into gray. I say I'll plow your driveway for $20. You said I'll think about it. You're thinking. Some amount of time goes by the time that you're thinking. Well, let's make it extreme. Summer comes, and you say, okay, plow my driveway. Well, realistically, when we spoke about that offer to shovel your driveway, it was winter time. That offer wouldn't be valid now because we're moving into summer and there's no snow and these sorts of things. So that would be unreasonable to accept unreasonable to accept that offer at that point in time. There is no agreement. If it was a week's time, maybe. The courts are going to look at it and say, well, what's reasonable? And what's reasonable is an ill-defined term. So the court's going to look at a whole bunch of factors depending on, is a month, is 2 months, 6 months, whatever. And it really depends on the product that you're looking at for the court to determine that. And that's going to lead, you're going to look at precedent cases and the like to see what happened there. But it's no telling. There's no defined date on when that offer would lapse. I can also revoke the offer. So I say to you, I'll shovel your driveway for $20. You said, I'll think about it. You go away. I call you the next day and say, my tractor broke. I can't do it. Sorry. That's what's called a revocation or revoking the offer. Okay. So revoking lapse happens because of time. Revocation happens because I pull back on it. Okay. So one requires an active pulling away the contract. The other one, the lapse, just time is going to do the job on it. Normally, the offeror must communicate the revocation to the offeree before the offer is accepted. So I really need to tell you that, no, I can't do this now. It need not be communicated in any special way to be effective. And this has run into problems too. The law has looked at this. There's been lots of cases where I revoked the offer, but you didn't get that message. I told someone, tell them that I can't do that now, and they forget to tell you, for example. Or I write you a letter and I put it in the mail, and between the time that the letter is sent to the time you get it, you try to enforce it. And I say, no, I told you in the letter, but you haven't gotten the letter yet. So these types of things occur. The only requirement is that the notice of revocation must be brought to the attention of the offeree before the offer is accepted. So there's the critical thing, is they need to be aware of it before they accept the offer. And we have run into lots and lots of court cases in time about this revocation not getting to them in time. Ending the contract offer, what does it take to make a contract happen and work and whatever? Well, completion is number one. But what happens if I didn't complete it? And what happens if, we've got this agreement, but I still haven't gotten to plow in your driveway? Well, time elapses, and whatever the time is, normally I would like that time to be specified. If I don't fulfill the contract within a week, it's over. A reasonable time, that's the court's going to determine. And effectively, contracts that have a seal in them, meaning it has this embossed mark, that is the company's embossed mark, don't need consideration. So it becomes a legal contract regardless if there is any mutual benefit or not. Again, so rare, but it is a truism in law that these seals, you don't need consideration for them.